It is my pleasure to have Jose Martin with us today. Jose is an attorney at law and a partner in the law firm of Richards, Lindsay, and Martin in Austin, Texas. His practice focuses exclusively on disability issues and litigation affecting public schools, including special ed consulting and litigation under IDEA, Section 504, and ADA. Mr. Martin graduated from the University of Texas and University of Texas Law School, and in April, he will be a practicing attorney for 30 years, and all of those years in special education. He has presented in more than 40 states and has been partnering with the Wyoming Department of Ed in guidance and professional development for us since the year 2007. So thank you, Jose, for joining us, and I'll turn it over to you.
Thank you so much, Ms. Shipley, and good morning, everybody. Yes, it is morning for you guys. You guys are a little bit earlier. You know, first of all, thanks for participating, and secondly, I want to encourage you to throw your questions in the chat. They don't have to be written fancifully. I enjoy and like answering questions, and they give me an idea of what kind of issues and concerns you have with respect to the particular areas. By the way, yes, I've almost been an attorney 30 years, and it makes you kind of think back to how it all started. When people ask me what I do and I tell them I'm an attorney, people always ask me, well, what kind of an attorney are you? When I tell them that essentially I'm a special ed attorney, I work with disabilities issues as they pertain to students in public schools. They routinely ask me, how'd you get into that? And the start of it is you kind of think about these things when you've been in the career quite a while. So going back to when I graduated law school in May on my birthday in 1990, and I was already working for a law firm that did school work, and I was working as a law clerk. That's how law students make a little money on the side. As a law clerk, what you do is you're doing research and writing for attorneys. So I was doing this on an hourly basis for a law firm that did school work. And then I graduated, and then it was the summer, and then I was preparing for the bar exam. And at one point, my senior partner, the boss of the firm, came to me in the library and wanted to talk to me. I remember thinking, oh my gosh, maybe he's going to offer me a job, because it is that time. And instead, he pulled me aside and he said, Jose, we have nothing for you. You better be looking for a job, you better be submitting resumes, because we're not adding attorneys. Just want to be clear, you're not going to get a job here. Okay, so you need to be looking for work elsewhere. I remember I went back to my cubbyhole to my research items, kind of bummed out, but I needed the work. So as I was putting out resumes, I continued working towards the bar exam, took the bar exam. I think that those days you took the bar exam in July and you didn't get the results until November. All during this while I'm working on an hourly basis. I don't really have a job. I don't really have any kind of a permanent job. Passed the bar exam, became a licensed attorney, still no job, still just working on an hourly basis for this law firm. And that continued for a few more months into 1991. And then one day on a Friday, I remember, because I was wearing jeans, one of the attorneys leaves and she's upset. And I asked, what's wrong with Susan? And they tell me they just fired Susan. Not 40 seconds later, I had Susan's job. The senior partner that had spoken to me previously brought me into his office, and in a literally 40-second conversation, he said, we'll give you an associate's position. Here's your salary. We don't do contracts. You're taking Susan's place. Go and move your stuff into Susan's office. You'll start. And I remember that as I was leaving excitedly, okay, because I accepted, obviously, I was leaving excited and almost closing the door to his office. He said, oh, by the way, Susan does only special education. So that's what you're going to do. And I remember thinking, I'm going to ask what that is tomorrow. Okay. I had no idea what that was, but I started with this large file of cases. Soon reached the surprise that one case was quickly going to go to hearing. So I had my first hearing pretty quickly. And Texas is the state where there is quite a bit of special ed litigation. You guys should be lucky that you don't have a lot of litigation. So your compliance orientation has to be based on complying with state education agency guidance and complying with the law, because it's what's best for kids. And I also want to say that I've been to states in the past that started as very low litigation states, and then over time it changes, and you'll be subject to potential legal challenges. So you always do have to worry about legal issues. In particular, this 2-hour presentation, I'm going to deal with two major topics. I was asked to speak on LRE issues, so I'll speak on LRE, and with a particular subtopic of LRE in preschool, which is a difficult area, and rendered a little bit more difficult by your peculiar separation between Department of Education, Department of Health. Is how you deal with pre-K programming. So I'll talk about the legal issues of LRE, some cases. The materials are broader than LRE and preschool programs. I may also touch on LRE and virtual programs, because obviously that's, I think, going to be on the upswing, as schools are reopening and some parents opt for distance or virtual learning. So I'm going to address those as well. But I gave you the full set of materials, so there's materials in other areas of LRE if you are interested. I may address LRE in the ESY context, in the context of additional summer services, because that's important as well. And then I'll finish with that and any questions that you have with respect to LRE. And then I want to talk about some COVID issues, special education and COVID issues that are going to be arising and that we need to worry about, both with respect to the time that schools were closed, making the change to return students to school programming, addressing potential issues related to compensatory education as necessary, and then addressing some particular and peculiar issues that are going to arise with respect to returning students to school in the context of a pandemic that's still going on. And I've been disappointed to find that you guys have had an increasing number of cases and a slightly increasing positivity rate. So you're nowhere near the problems that we have in Texas. We have pretty high positivity rate, large number of cases, and that has continued. But you still have to watch out for these things. So I'm going to get on with the LRE issues, okay? Initially, in this type of a presentation, when we talk about least restrictive environment, in a live presentation, usually I like to throw out the question of what is LRE? And that's the acronym for least restrictive environment. And I throw out that question because the term to me is not self-explanatory. I don't know why they gave it that name, least restrictive environment. It actually has nothing to do with restriction. To me, it has to do with the degree of segregation from non-disabled students. In fact, I think that a better way to think about least restrictive environment is LSE, least segregated environment, because that's what we're shooting for. We're shooting for providing a FAPE to a child in an educational setting where they have maximum exposure to non-disabled kids. In other words, where we're segregating them the least from non-disabled kids. That's really the LRE. Normally, when I ask that blind question, just what's LRE, a common answer is the regular classroom. And to which I normally respond, so any child that's in a special ed classroom, you're violating the law? And people are like, well, no, that can't be possible because we've got lots of kids in special ed classes. So I ask again, well, then what is the LRE? And obviously what is the true answer is that LRE is a fluid concept. LRE can vary with each student. For some students, the educational setting where they can receive a FAPE with maximum exposure to non-disabled peers is in fact mostly in a special ed classroom with some limited mainstreaming, because otherwise they can't get a free and appropriate public education. The reason we have special education environments is that for some students, their IEPs cannot be fully implemented properly in a regular education environment, which is another way to look at LRE. Okay, you can also think about it as the least restrictive environment, student to student, is the educational setting where you can implement the child's IEP while allowing for maximum exposure to non-disabled peers. Okay, so that's the idea of LRE. I wish to also comment that the least restrictive environment is one of the fundamental pillars of special education. Yeah, I see special education as this complex house, but it is ultimately built on 4 pillars. One big pillar is parental participation. Another big pillar is annual IEPs. So we do annual plans for the child's education. The third pillar is that decision-making is based on evaluation and data. But the fourth pillar is least restrictive environment. Since the inception of the law in the mid to late 1970s, the Congress wanted to ensure that special education funds wouldn't be used to separate students with disabilities from students without disabilities. That was morally, ethically, and educationally wrong. Okay, why educationally? Because there is a lot of value from students with disabilities being around students without disabilities. And it's not just the modeling opportunities, although that can be significant, okay, because students model other students. So modeling appropriate social interaction and social skills, modeling appropriate behavior, modeling appropriate verbal skills, modeling appropriate academic skills can be important to students with disabilities. But the work of folks like Dr. Lou Brown at the University of Minnesota made me understand that it's more than that. And it's about relationships over time, that you want special education students to develop relationships long-term in school with non-disabled peers, because those non-disabled peers will be the bank owners, the restaurant owners, the garage owners that may hire them. And you know the importance of friends and relationships in terms of career opportunities. In my little background story about how I started in this business, I didn't tell you that the very, very beginning was that a law school friend of mine got me an interview to get this clerking position on an hourly basis. Without having had that relationship and that friend in law school, I wouldn't be in this situation. So that's super important. And this is part of why, from its inception, the Congress installed the least restrictive environment provision. It was out of a fear that the funds would be used to just warehouse and segregate kids, put them in separate facilities, but also from the standpoint that there's benefits to educating students with disabilities with students without disabilities. And I think that over time, what that has led to is, I think non-disabled students at many times are far more comfortable with students and persons with disabilities than some of the people from my generation are, because they've been exposed to that since they were little. When I was in elementary school in South Texas way back, I knew there were special education students. I would see them from afar going to their, by the way, substandard portable facilities, but I never got near one. Never was there one in my classroom. Never did I get to know one. That's the way things operated at that time. It was a time of segregation. So this is what the least restrictive environment provision is intending to accomplish. It's a very, very important concept in special education. It's an area and a concept that has been studied very broadly and has been maintained in the law, and that has led even to evolutions in educational practices. I was just thinking with a special ed director that I've worked with over a long period of time, and she and I were reminiscing about the time when resource classes were the bomb. You had resource math, resource reading, you had all kinds of resource classes because 20 years ago, the model for special education was the student had to go to a different setting to get their specially designed instruction. So we had these separate resource classes. And notice how the times have changed over the last 20 years. That has been seen as kind of an outmoded way of providing special education, and actually not a super beneficial way, because it also led to reduced expectations for students. And that rather, we see now special education as a service rather than a place and a setting. And that in many cases, that what was available in the resource classroom in terms of specially designed instruction can be brought within the context of regular ed instruction, and thus the advent of inclusive practices. Instead of the mountain going to Muhammad, why can't Muhammad come to the mountain? Why can't the special ed service come to the student in the context of a regular class? And why can't a special ed teacher come into the regular classroom setting and provide the specially designed instruction that a child may need in order to participate to the extent appropriate in the regular education curriculum? And that has led to other practices, such as collaborative classroom environments that are run by a special ed teacher and a regular ed teacher together. All of these are outgrowths of LRE, a fundamental concept in special education law. At the bottom of the slide, I give you another piece of the LRE requirement, and that is that you're not supposed to take special ed kids out of the regular class unless you cannot provide them an appropriate education with special ed, supplementary aids and services, or other kinds of services in the regular class. Okay, so there's this idea that the LRE requirement pushes us to provide instruction to special ed students within the context of regular ed classes to the greatest extent possible, and that we actually remove them to the special ed environment as little as possible. Admittedly, this depends. Some students have very severe and profound disabilities, and the regular curriculum is not necessarily appropriate for them. And thus, what we see is that there is a sliding scale. For some students, the least restrictive environment, in fact, is quite restrictive. They are quite separated, and they are perhaps in a life skill setting most of the school day, and can only be in a regular classroom setting for part of the day, because otherwise their needs can't be met. And ultimately, FABE comes before LRE, okay? You have to provide students an appropriate education. What's an appropriate education? The Andrew case out of the Supreme Court in 2017 clarified that an appropriate education is the provision of an IEP that is reasonably calculated to enable the special ed student to make appropriate progress that is appropriate in light of their circumstances, in light of the severity of their disability, the complexity, the multiplicity of disability, other environmental factors. But that's what we're shooting for. We're shooting for appropriate progress. And secondly, we want that appropriate progress to happen in the least restrictive environment, okay? That's the idea of the concept of LRE. Another mind exercise that I like to play with LRE to help folks understand what the requirement really is let's do this mental exercise, okay? And there's two classes and they're right by each other, okay? And let's say that they're math classes. In this math class, let's say math classroom A, the child with a disability, the special ed child, would get an appropriate math education, okay? And it's a regular ed class. Now this is a special ed class. In this special ed class, only special ed students, the child would get an excellent math education, only appropriate in the regular class, excellent in the special ed class. Where does LRE say the child goes? The regular ed setting where he's only getting an appropriate education. LRE implicates a sacrifice of the best or maximal program, which is not required under IDEA, only an appropriate one, okay, to ensure that the students are getting at least an appropriate education, but with exposure to non-disabled students, okay? Because if the idea was the best education for all students with disabilities, obviously everybody would be in a self-contained classroom. Self-contained classroom, you have the lowest staff to student ratio, you have specially trained teachers, a lot of capacity for one-on-one instruction, you'd get the optimum education. But what LRE says is that don't worry about that, don't shoot for that. You're shooting for an appropriate education so that we can have the students with disabilities in the regular ed class, again, to the maximum extent possible so that they're exposed to non-disabled peers to the maximum extent possible. And let me know if you have any questions on this foundation concept. By the way, I've cited the LRE provision of the law, but importantly, there's a little bit more to it than this, okay? This is the broad requirement, the fundamental requirement under the law. The way we operationalize it is that the Department of Education then, over a long period of time, has promulgated federal regulations that in more detail tell us how we comply with the LRE requirement. And I want to go over those regulations. And you guys can look them up. Nowadays, it's so awesome. You know, 25, 30 years ago, if you wanted to look up the federal regulations, it was a job. You had to go to a law library and actually look them up in a book. And if the regulations that you wanted, you would actually have to copy them. Make Xerox copies of them and then take them home. And that's how we did legal research. Nowadays, in the world, the age of the internet, if you want to read 34 CFR 300.114, which is a federal regulation, all you have to do is Google it. You put in there 34 CFR 300.114, you're going to find it right off the bat, and you can print it. Okay, and so, you know, nowadays all these regulations and laws are easily accessible. But I want to go over the regulations that kind of operationalize and tell us exactly, you know, how schools must implement LRE and comply with LRE. And the first regulation actually does nothing other than restate the basic requirement that we had in the previous slide. It just says special ed students need to be educated with non-disabled peers to the maximum extent appropriate. Got it. You know, we knew that from the legal provision of the actual statute. Okay, now more details, okay? If you're gonna move a special ed child from a regular class setting to a more restrictive setting, let's say more special ed type of placement, less exposure to non-disabled students, that move can take place only after the IEP team has properly determined that we can't provide the child an appropriate education in the less restrictive environment in the regular class, even when we have applied legitimate efforts at providing supplementary aid services and accommodations, okay? Because it's not just about planning the child in the regular class, boom, you know, cold turkey, it's not working out, okay, let's move them to special ed. No, the idea of the regulations is if you have a child in a regular class, if they need assistance in order to participate and progress in that regular education class, the job of special education is to pump assistance into that regular education class in the way of services, accommodations, supplementary aids and services, and so forth, okay? I know that they use the term modifications. While educators definitely distinguish very strongly the term accommodation from modification. Accommodation is an adaptation to either delivery or the provision of services that does not alter the underlying course content. And modification can alter the underlying course content. That can break down somewhat in the use semantically of the terms in federal law and guidance. Although I must point out that in special educations, modification to curriculum is possible. Like I indicated earlier, in special education, at times we're serving students whose disabilities are so severe that they need a specialized curriculum that is not part of the state mandated curriculum, or they need a lower level curriculum than the chronological age level of curriculum. And that is allowed under special education, so that is possible, okay? But this is a fundamental regulatory concept. We only place children from less restrictive environments to more restrictive environments if it's absolutely necessary to confer a FAPE, and if we have kind of tried legitimately to assist the child in the regular classroom, and we just determined it's not possible. It's not feasible in the regular education classroom. They're a really key fundamental piece. And you'll see that the federal court approaches to LRE match this, okay, and recognize this. Okay, the next requirement of the regulations is school districts have to have a variety of different types of placements. You know, it's not just one setting, but rather you have everything from full regular ed classroom to mixes of regular ed and special ed, a variety of types of special education settings, all the way to even homebound instruction, hospital class instruction, okay? So, and the way the name we give, or that the law gives to this variety and mix of placements is the term continuum of placements, okay? So the districts have to have a mix and a variety of available placements for special education students, okay? And you'll see that that allows for gradual moves up the ladder of restrictiveness, which we'll talk about in a little bit. Okay, the next regulation says IEP teams are the ones that decide where the child receives an education, what's their placement, okay? It's the IEP teams that are responsible for ensuring the compliance with the Lre requirement, and placement decisions have to be made on an annual basis, like IEP is made on an annual basis. And that relates to the next concept in the regulations, and that is that placement decisions have to be based on the IEP. The sequence in IEP meetings whereby you look at evaluation data, present levels of performance, and then you figure out what the goals are for this coming year, and you figure out how we're going to measure progress, what services are necessary in order to enable the student to master those goals. The reason that comes first is that once we've decided what the goals are and what services are required, then we make the placement determination, because the idea is that placement has to be based on the student's IEP. We determine the IEP first, and then we ask, what is the least restrictive environment within which we can implement this IEP? Thus the sequencing. The IEP decision making comes first, then comes the placement decision and the placement question. What's the least restrictive environment within which we can implement and hopefully master these goals and objectives and implement the services that are in the student's IEP? Okay. By the way, the Department of Education in Wyoming has a very nice short document that goes over the Lre requirements. It goes over these requirements, and it actually goes over the approaches of the federal courts to Lre. It's a very, very nice short document in terms of encapsulating the content and the substance that I'm discussing here, in case you want to look at that, okay? Then we have a couple of other regulations, because there's a little bit more to restrictiveness than just ensuring, to Lre, than just ensuring that the child is in regular classes. The Congress says, we would like students with disabilities to go to school where they would go to school were they non-disabled, okay? Like their home school or their neighborhood school. That's part of Lre, that you're going to the school where your neighborhood peers are going. Thus, the requirement of the regulations, this one in 34 CFR 300.116. If you see a regulation, it starts 300 point something, you know it's a federal regulation. Say, unless the IEP requires some other arrangement, students with disabilities should go to school where they would attend if they weren't disabled. Important, okay? This establishes that the default, the preference of the Congress in terms of Lre is that students with disabilities go to the school that they would go to if they weren't disabled. But with an understanding that at times the neighborhood school might not have the placements and services available that are necessary to implement the IEP, because every school doesn't have to have every part of the continuum of placement. So at times the child's neighborhood school cannot implement the student's IEP, and the child must be sent to some other campus. And then the next regulation says, if you can't educate the child in their neighborhood school, then put the child in the next closest campus to the child's home that can implement the child's IEP. So do you notice the preference here? We'd like the child to go to their neighborhood school. If they can't go to their neighborhood school because they can't receive a FAPE there, their IEP can't be implemented there, then we want them to go the closest possible, the next closest campus that does have the appropriate services to implement the child's IEP. Okay, an important requirement. This one has to do more with campus issues with school. LRE isn't just about the particular classroom. LRE is also about campus, okay? And the Congress prefers, again, for kids with disabilities to go to school where they would have gone to school if they were not special ed, okay? But if they can't go to school there because their needs can't be met, and remember, FAPE comes first, then let's put them as close as possible to the child's home, you know? That's the idea of campus and LRE decisions. So let me know if you have any questions on that. Okay, then we have an issue about consideration of harmful effects. This is an important regulation. When we make placement decisions as an IEP team, we must consider any potential harmful effect on the child or on the quality of their services, okay? Whether we are making a decision to move a child to a more restrictive environment, or we are making a decision to move a child to a less restrictive environment, the IEP team has to think, consider, ponder potential harmful effects. Every placement change, there's pros and there's cons. When you move a child to a more restrictive setting, the pros tend to be this will better allow implementation of their IEP. They'll get a better shot at FAPE. They'll get more individualized services. They'll get more superior trained staff to implement the services. But there's cons, okay? When you move the child to a more restrictive setting, you are reducing the modeling opportunities with non-disabled peers. You're reducing their exposure to non-disabled peers. You're potentially reducing their access to grade level instruction, okay? So every move has pros and cons. Not only to a more restrictive environment, but also to a less restrictive environment. When we move to less restrictive environments, the harmful effects tend to be there is less capacity to provide individualized assistance. There's greater numbers of students in less restrictive environments. There is less of a capacity to implement complex behavioral interventions. There's less ability to meet the child's more unique needs because it's more difficult to provide very specialized instruction in the context of less restrictive setting. The benefits are you've got more exposure to non-disabled students, you've got maximum modeling opportunities for non-disabled students, you've got better access and exposure to the regular curriculum. So whether you're moving for more restrictive placement or less restrictive placement, there's potential harmful effects. And what the law says is you can't blow off the pros and cons. You've got to talk about the cons of every move, every placement decision. You've got to talk about harmful effects. I'm sure that in your fancy software-based systems, when you have the LRE issues, you'll have an area there that says you've discussed potential harmful effects, and it kind of makes you go through that. Okay, and at times the parents will point out a harmful effect, or staff must point out a harmful effect. The point is that there's harmful effects with moves in placement because there's always cons to every change in placement, and those have to be discussed by the IEP team. At times a harmful effect can be dealt with other services. At times a harmful effect is one that we just have to deal with because of the priority to provide a student a FAPE. And then the last regulation, which is one of the newer ones, I think added in 2006, is we don't remove students from the regular classroom just because they need classroom modifications, okay? Just because they may need a slightly modified curriculum, or they need accommodations, or they need a behavior intervention plan, or they need assistive technology, we're not going to remove a child, okay? So it's basically an outgrowth of the idea we already know, which is you have to make sure that you make legitimate attempts at introducing and putting in special ed services, supplementary aid services, modifications and accommodations in the regular class before you determine we can't do it here in the regular class. And you'll see that the federal court analysis kind of follows up on that. Okay, any questions on that? Don't be shy with questions, you can ask. The LRE analysis of the circuit courts, I want to point out, as is pointed out in the Department of Education's LRE kind of pamphlet or write-up or summary, that there's various analyses that the courts use to determine if you have complied with LRE or not. And there's three major approaches, and I'll tell you which one applies most to you, okay? This approach is called the Ronker approach. It applies in the Sixth Circuit, and I've set forth the states that it applies to, and it's not your state, but I want to look at the formulation. They basically ask, initially, it's sort of like a three-question approach, and they say, can the student benefit from mainstreaming? In other words, can the child essentially receive a FAPE in the regular classroom? Is that possible? And then kind of a weighing issue, they say, would the benefits of mainstreaming be outweighed by the benefits gained in a more restrictive setting? Okay, so, and a recognition that there's some benefits available in mainstreaming, but they might be outweighed by the fact that the student can receive FAPE or a restrictive setting is necessary to accomplish the benefits that are coextensive with the receipt of a free and appropriate public education. Now, they do ask a sub-question is, could services feasibly make FAPE possible in the mainstream setting? You know, again, it goes back to the regulations. You have to make legitimate attempts within the regular classroom to make things work for the child with disabilities before you decide we're going to move into a more restrictive setting. And in the Ronker formulation, they say cost is a valid consideration. You know, in many, many situations of special ed law, cost is no issue, right? You've heard it doesn't matter if it costs $1 million to educate the child, then that's what it takes. But with respect to compliance with LRE, a variety of courts say, you know, there's not unlimited funds that a district's going to be required to expend just to keep a child in regular class. Okay, so the cost of keeping a child in regular class must be reasonable. You do have to provide services in the context of a regular class environment, but the expectation is not that even if it's unlimited or unreasonable cost that has to happen. So this is a finite area of law where cost is an issue, is a valid issue in the consideration. And then lastly, the Ronker analysis asks whether the student is a disruptive factor in the regular class, because that's kind of a bummer, right? And if the child is a disruptive factor in the regular class, it may mean that that's not appropriate setting for him. And here's another area where LRE doctrine kind of departs from normal doctrine. Normally, the impact that a child has on a regular education student is it's kind of irrelevant for purposes of FAPE, but it is not irrelevant for purposes of LRE. If a child exhibits lots of disruptive behaviors in class that disrupt or the teacher's ability to teach or other students' ability to learn, that is a factor that tends to militate towards the fact that the child may receive a more restrictive environment. And you'll see that other courts also follow that. That's almost universal to all courts. Okay, the next formulation is what I'll call the good one. Okay, and the reason I say it's the good one is probably most areas in the United States ascribe to this analysis of LRE, which comes from a Texas case out of El Paso, Daniel R.R., a 1989 case. And that's a Fifth Circuit case, but it's been adopted by a variety of other circuits, including yours. You're in the 10th Circuit. Wyoming is in the 10th Circuit Court of Appeals, and it has adopted the Daniel R.R. analysis. Okay, and it's kind of two-parter. And it's the most complicated of the analysis. But the first part is, can the student be full-time in regular class with appropriate supplementary aids and services? Okay, that's the first part. So the first part asks, can the child be in regular class all the time, fully mainstreamed? And then 6 sub-questions or sub-factors help answer that question, whether the child can be in regular class with supplementary aids and services and special ed services full-time in the regular classroom and receive a FAPE. And the first question is, have you tried school? That's a basic question. Has the school attempted placement in regular classes? This part of the Daniel RR analysis almost tells us that when you are initially placing a child in special ed, that the default placement is full-time regular classroom. Isn't that unique? Isn't that interesting? That as you're placing the child in special ed, the law is essentially telling you, oh, you're putting the child in special ed? Okay, full-time regular class for him. It's sort of pointing out that special ed is not a place, but a service. And the default is that the child can be provided an appropriate education full-time in regular class if you provide special ed and other kinds of services within the context of the regular class. So the first step is, have you tried? Have you tried full-time placement in regular classes? Okay. And then the second question related to that is, were your efforts at educating the child in the regular class serious efforts? They can't be mere token attempts. The efforts at providing special ed, supplementary aids and services, and other forms of assistance to a child with disabilities in a regular class have to be meaningful. They have to be serious. They can't be fake just for purposes of saying, see, it didn't work. Okay. So the second question asked by Daniel RR is, the efforts at integrating the child full-time in regular class have to be meaningful. They have to be sufficient, okay? The third part of the Daniel RR analysis, which again is, can the child be full-time in regular classroom? And the third sub-question is most of the teacher's time going to have to be devoted to meeting this child's needs or to modifying the curriculum for this child? Because if a lot of teacher time is if the regular teacher's time is going to be devoted to this student, that's an indicator that maybe that's not an appropriate environment and that the child may need a more restrictive setting. So this one, if you notice, is teacher focused. So if too much effort is required on the part of the teacher to be devoted in the time that is needed for the child with disabilities or to modifying their curriculum, that tends to be an indicator that the child, in fact, legitimately needs a more restrictive setting. And part of this is, obviously, if most of the teacher's time has to be devoted to the special education student, it means that less teacher time is devoted to the rest of the kids. And that matters for purposes of LRE. Okay, maybe not in other areas of special education, but it does matter here. And the fourth sub-question is, can the child even receive any educational benefit in the regular classroom? I mean, for some students, their experience in the regular classroom kind of tells us we don't know that they can progress. Even with appropriate supplementary aids and services, we're not sure that their needs are such that they can be met in the context of a classroom with potentially 25 other kids. So that's kind of a fundamental question. Can the child receive an educational benefit in the regular class? And that's related to the next question, which is, what has the child's overall experience been in the regular class? Okay, I remember I had a case back in the early 90s, which was the zenith, the peak of inclusion advocacy back in the early 90s. And it was a case where it was the child with a mild to moderate intellectual disability. We called it MR at that point, and the parent wanted more classes in regular education. And the hearing officer, and this was unusual, wanted both attorneys to observe and the classroom environment. And the attorney in the case, which is a friend of mine, and I, we both went to the classroom, and I remember my thinking and what I was observing was aligning to these factors. And So one thing that I was looking for was what appears to be the child's experience in the regular classes. And this was a young lady, and their experience in regular class seemed to be a happy one. Kids were interacting with her. She seemed happy. She was participating. She was working. She seemed a part of the regular education class in a very natural way. So I remember marking this one. This one seems to indicate that the parent's right, that the child can be in regular class. And then I remember thinking about the next factor. And the next factor is related to the Ronker factor about disruptiveness. What is the child's impact or effect on the classroom and other child's education? Remember that really that normally doesn't play into special ed decisions, but it does in LRE, okay? Because if a child's having a negative impact on the class, on the regular classroom and other students' education, to the law, that tends to be an indicator that the child needs to be in a special ed classroom at least more of the time. And I remember with this young lady, I was also looking for that. Well, what's her effect on the classroom? And I remember thinking, oh my, her effect on the classroom seems to be very positive. She participates, she helps, she's helping collect. You know, I remember that at one point, you know, she was asked to help with collecting the trash, and she dutifully, you know, collected all the trash, happily did so, finished her task. And it seemed to me that in the time that we were there, I could not see one hair of negative impact. It didn't even seem that the teacher was having to expend a lot of extra time with the student. She seemed to participate naturally with her modified assignments and so forth. So I remember thinking, this is starting to look like we're going to lose this case on LRE grounds, because she seemed to have a very positive impact. Now, the reverse could be, what if in fact this is a student who has frequent screaming outbursts, aggressive behavior, explosive behaviors, where the class has to be cleared, and it takes a while to regain composure in the classroom. And obviously that's the type of situation where this factor would tend to indicate the child might need to go to a more restrictive setting. Okay, so if you notice, this is an area of special ed where the special ed child's impact on the other kids is germane, is a valid consideration, okay? And that's the first part, okay? So if an analysis of those 6 sub-factors tend to indicate that the child cannot be full-time in regular class, then the second part of the Daniel R analysis says, okay, if you can't have the child full-time in regular ed, have you put the child in regular ed to the maximum extent appropriate? Because even if the child can't be full-time in regular ed, we want her to be in regular ed as much as possible, okay? And this analysis envisions a gradual move up the ladder of restrictiveness. In other words, if the child can't be educated full-time in regular class, then we'll have to add some special ed classroom instruction. Maybe the child does have to be removed from the regular ed class for some part of the day. If that doesn't work, then we might have to remove the child from the regular class and put her in a special ed classroom for more part of the day. But the idea is, you try to avoid these A to Z movements in restrictiveness. You kind of are going up a ladder gradually. Okay, you don't move from full-time regular classroom to full-time self-contained classroom. Okay, that's the idea of Daniel R. And remember, that's the formulation for you. So I'll give you more advice on that as to how to use this analysis in making IEP team decisions. The Rachel formulation is the third formulation, and it kind of meanders and it kind of touches on some of the areas of the previous court cases. And this one doesn't apply to you, but just to go over it, it says, what are the educational benefits that are available to the child in regular ed class as compared with a special ed class? And this sounds like the Ronker formulation, like what are the benefits in the regular ed class vis-a-vis the benefits in the special ed class? And then they throw in another, what are the non-academic benefits of interaction with children who are non-disabled? Here recognizing that the modeling that can occur from non-disabled students, in other words, that intangible, the fact that we learn from our peers quite a bit in the classroom environment, is what's happening there? Is the child having a modeling benefit from the regular class? And then the last one, which is kind of common to all of the analysis is what's the effect of the student's presence on the teacher and other students in the regular classroom environment. That's highly important. Again, this goes back to whether the student is having a negative impact on other children. Okay, and lastly, with Rachel, is what's the cost of keeping the child in the regular classroom? Because if it's exorbitant, if it's unreasonable, it may mean that a more restrictive placement is in fact required. And again, this is an area where cost is a factor in the consideration, where normally it is not a factor in the FAPE consideration. It can be a factor in the LRE consideration, and that being the cost. Hearing officers in federal courts, when they analyze whether you complied with LRE or not, they're going to apply those analyses. And these is the legal analysis that can help IEP team members in making the placement decisions. So if you guys are kind of dealing with a tough issue as to should we move the child to a more restrictive setting, is that necessary or not? For you guys, I'd probably say ask these questions in the Daniel R analysis, okay? See where these questions lead you, okay? Have you tried regular classes? Have you tried with feeling, okay? Meaningful attempts? Is most of the teacher's time devoted to the child in the regular class? Can the student benefit in the regular classroom? What's been the overall experience of the child in the regular classroom? And what impact or effect does the disabled child have on other students' education in the regular class? And if the child can't be full-time educated in the regular classroom, are we educating the child in the regular classroom as much as possible? That's the basic idea of the Daniel RR analysis, okay? Now let's talk about some challenging areas because I want to get to preschool programs. And the point I want to raise in this overall presentation is that although we are told LRE applies equally in all contexts, in practice, it's not always treated in the same way depending on the legal context. And in some areas, the traditional LRE analysis is not a good fit for new and more innovative placement options, okay? And I want to talk now about preschool programs, okay? Preschool, in special education, students are entitled to a FAPE starting on their birthday at the age of 3. And you know that for regular ed kids, let's say that in your district there's not a pre-K program, that means they can start in kindergarten. But for students with disabilities, you know, kindergarten generally 5. Students who are eligible for special education can begin getting special ed services at 3. You're required to provide a FAPE during that age 3, 3rd year, and 4th year, okay? And the LRE difficulty that is presented is, well, LRE is always about exposing students with disabilities to non-disabled students, usually in the context of a regular education program, right? Now, the LRE difficulty in the preschool context is that your district might not have a regular pre-K. Regular pre-K is not mandated by federal law. Not every state has universal pre-K. In fact, I haven't studied this, but I think it's possible that the majority of states, they leave it up to individual districts where they have a pre-K program or not. It is not seriously argued that other than pre-K programs are helpful, that students that you know get pre-K programming starting at age 4, and I mean regular ed, non-disabled kids, whatever, that it's beneficial and that they just do better educationally with pre-K. But it's not a national mandate. There's no federal law that says schools have to have pre-K. And in most states, mine, yours, there's no state requirement that schools have pre-K. It's if they want to create it, they can create it. There may be some grant programs available, but it's not mandatory. And I know that in Wyoming, there's quite a few districts that don't have pre-K. The difficulty is this. For special education students, if you have a 3-year-old, they're entitled to special education services. But now here's the rub. Are they entitled to LRE? And how do you do that if you don't have a pre-K program? Obviously, they don't even have a 3-year program. Nobody has a 3-year regular ed program, okay? So the difficulty in the context is in these schools, there's a tendency to provide preschool programming on a separate basis in classes. Usually they're preschool programs for children with disabilities. And in your unique system where another department of the state of Wyoming kind of takes care of preschool for you, my understanding is there are some attempts at bringing regular education students into the context of these special education preschool programs, likely because over time with monitoring from the Department of Education in Washington, they've pointed out you have to comply with the Lre requirement with respect to preschool students, okay? So the question that I ask for purposes of this presentation, is there any flexibility in the Lre requirement for preschool programs, since we all need to understand that some districts might not have regular pre-K programs? And the answer appears to be no, there is no flexibility. In other words, the answer appears to be that a 3-year-old special ed child's, a 4-year-old special ed child's right to Lre is undiminished because of their young age. And they have the full Lre rights that a 10-year-old would have, okay, to have exposure to non-disabled students as part of their educational program, okay? And that is a solid challenge to schools. Because think about it, okay, let's say you have a 3-year-old with a significant speech impairment, they qualify for speech. The tendency for schools is, okay, here's your speech session. You get weekly speech. Where's your Lre? Well, actually, Lre, well, exposure to the speech therapist. Yeah, but those aren't peers. And you know, what Lre is about exposure to non-disabled peers. This child with a speech impairment is 100% special ed. I hate it when people say the student is speech only. Have you ever heard that? Speech only. I'll tell you what I've never heard. Oh, he's AU only. He's ED only. Never have heard that. But I hear he's speech only. To me, it's always sounded like, I'm a little pregnant. Just got a touch of the pregnancy. I'll get better. You know, that's not how it works for me. To me, you're either special ed or you're not. You know, your whole body goes into special ed. Okay, you're not just your mouth went into special ed. When you're a child with a speech impairment, you're a special ed child, and you have all of the rights that special ed brings with them. You're not a little special ed. Okay, there's no such thing. You're either special ed or you're not. You're either pregnant or you're not. Okay, and once in special ed, this speech child, a parent can say, "Hey, where's my Lre? My child's entitled to Lre." How are you accomplishing maximum exposure to non-disabled students? And then you think, but we don't even have a pre-K program, okay? And that's the question, is how do we comply with Lre for preschool students with disabilities when perhaps there's not a pre-K program? When you have a pre-K program, cool beans, you can integrate this child with a speech impairment for at least part of the day into that pre-K environment, even if it's 4-year-olds or close enough. So that can be how you offer and comply with Lre. And by the way, it's not a bad thing, because this child with a speech impairment will get modeling from 4-year-olds with appropriate speech. And it potentially can even enable the student to progress further. Not only that, but there's other intangible benefits. They're going to be modeling more group behavior. They're getting an advanced knowledge of more advanced academics. So that's the good stuff. That's the reason why Lre in the preschool programs is the same. And the point I want to raise is this, is that as far as the courts are concerned, Lre applies equally in the preschool context, even if it's more difficult for you. That's the major point. Okay. And there's a regulation, 34 CFR 300.116, which we've covered. But if you look at the commentary, every time that they issue federal regulations, the federal government also issues significant commentary. And the commentary that was issued in 2006, if you look at that page of the Federal Register, it says, guess what? Lre applies to preschool settings, okay? And it's something that the Department of Education had said in the past. In 1996, the Office of Special Education Programs out of Washington, in a letter to Neville Dean, said LRE applies equally in preschool settings, even to preschool students eligible only for speech services, the example that I was talking about just before, okay? And in 2012, they expanded. The Dear Colleague letter says, hey guys, LRE applies even if the district has no pre-K. If you've got no pre-K for LRE, you're gonna have to explore the kid may be going to Head Start, or you may have to pay for private preschool. What? Or you might have to contract with another public school that does have pre-K, or you have to provide home-based services. That last part I don't understand, because home-based services would seem to me to separate the student from students, not integrate them. So that last part I don't quite understand. And even older cases follow this line. The LaGrange case from 1999, the parent said, hey, my child's preschool, but where's my LRE? And the school said, tough, we got no pre-K. So we have no regular pre-K to integrate your child into, so you're out of luck. And the parent said, let's see what the judges say. The parent filed due process, and it went to federal court and to the circuit court. And the circuit court said, you know, this kid's entitled to exposure to non-disabled peers. And if the only way that you can expose this child to non-disabled peers is by means of integrating the child into a private preschool program, then you're going to have to do that. You're going to have to, school district, you're going to have to pay for the private preschool program. Since a student was capable of being mainstream, but you offer no regular pre-K, you're going to have to buy mainstreaming elsewhere. Of course, they lucked out. $75 a month for a private school. I wonder how much they paid the attorneys to go to the Seventh Circuit. I think they paid a lot of tuition to the attorneys. Well, tuition for their attorneys' kids to go to college, I think. A letter to Anonymous in 2009 made very clear that LRE, the Continuum of Placements Requirements, applies to charter schools, okay? So if you're a charter school that is participating in this program, I want you to know that the LRE requirement applies equally to charter schools. Most of IDEA, you know, charter schools may be free from some requirements of state law, but you are free from no requirements of federal law. Charter schools must comply fully with Section 504, must comply fully with IDEA, including with respect to LRE and Continuum of Placements. Yes, that is absolutely true. A couple of cases that I want to talk about. Firstly, there's this Fairlawn case from the Third Circuit from 2012, and I'll kind of tell you the situation. Yeah, there's a young girl with autism spectrum disorder. It's one of the benefits of our increased understanding of autism spectrum disorder is that it has been probably underidentified or misidentified in females, and that probably more girls had autism than we thought. It used to be known as primarily a boy thing. Now the opinions are changing among the experts. Okay, so anyway, you have a young girl with autism spectrum disorder, and the school district, and this is a preschool girl, the school district proposes a special ed classroom that's specially designed for students with autism spectrum disorder. And also as part of the program, they are going to provide some one-to-one ABA, applied behavior analysis, ABA-oriented type of services. The evidence appears to indicate that if you have the student in a regular class, she doesn't necessarily model from the regular students because she doesn't notice other students or interact with them. You know, there are modeling opportunities for students with disabilities in regular classes, but it doesn't mean that they are going to model, okay? Some students do. Some students are keen observers of other students and mimickers. Other students not. This student not. This student neither noticed nor interacted with non-disabled peers. In fact, during pre-K classroom, she just would wander aimlessly in the classroom and not participate. Moreover, the court noted that the student, to really do any task, needed lots of one-on-one instruction. And in the period of time that she had been in the autism special ed classroom, she'd made good progress. And as part of this school, you know, is doing a pretty good job. They have a very specialized classroom. They provide ABA instruction. And if you notice, they have a reverse inclusion type of program where regular ed students are actually brought into the autism classroom for interaction with typical peers. Okay, so you can see where this is going. The court says, we think that the child needs the special ed classroom because she's not really benefiting from the regular ed classroom. There's no non-academic or modeling benefit in the regular ed classroom. The overall experience in the regular ed classroom is she's just wandering aimlessly and not interacting with kids. And her educational needs are such that she requires lots of one-on-one instruction, meaning most of the teacher's time in a regular pre-K class would be devoted to the child. And she even has some opportunities for interactions with typical peers because the school is reverse including typical peers into the classroom environment. So the court says this complies with LRE. Okay, in order to receive a FAPE, the child needs to be in the ASD classroom, and there is some opportunity for interaction with typical peers, so there is compliance with the LRE requirement. Nevertheless, I do want to point out that the case says we are proceeding from the proposition that LRE applies with equal force in the preschool context, which is the point I want to make. You can't say that LRE applies fully to 10-year-olds, but not to 4-year-olds with disabilities, just because you don't have maybe a 4-year-old pre-K. It applies equally, okay? If you can't say, you cannot in court say, well, you know, it's a 4-year-old, we don't have a pre-K program, so give us a break, federal court. Federal court's gonna say, sorry, LRE applies with equal force. Show me how you are complying with LRE, how you are affording this child with a disability maximum exposure to non-disabled peers. Otherwise, you lose the case, okay? The Tuxedo case out of the Second Circuit, kind of a reverse situation, very different on the facts, although similar disability. Okay, so here you have a child with pervasive developmental disorder. We no longer use that terminology, do we, right? Because in the DSM-5, the psychologist decided just to create one big umbrella disability for autism spectrum disorder, which swallowed up, you know, autism and PDD, childhood disintegrative disorder, etc. So, but anyway, so this child probably in the spectrum, let's call her ASD, autism spectrum disorder. And she's a preschooler, and the school's saying, we need her in a special ed classroom. And the parents said, no, we think this student should have at least some time in a regular ed classroom environment. And the school's position was, but we don't have a pre-K program. And apparently the parents had placed her on their own in a regular pre-K program, probably a private program. And in fact, this student, as opposed to the student in the previous case, this student appeared to model typical peers and mimic appropriate behaviors and was making good progress in this regular pre-K class with some one-on-one assistance in this regular private pre-K program. And the public school just could not come up with an argument as to why it was not possible or feasible to provide this 4-year-old with an appropriate education in a regular pre-K environment. And so the court district held full-time placement in a special ed class for this child that we know is making good progress in a regular pre-K with some one-on-one assistance. You're losing here, school district. And so the school district lost and was awarded tuition reimbursement. The parents got their reimbursement in the private pre-K program, okay? Here's, I think, a situation where the school district was thinking, well, we don't have a regular pre-K, so we're just gonna stick her in a special ed classroom all day long. And the parents are saying, but she's doing okay in this private pre-K program. And the school district probably at that point should have responded by brainstorming, how do we get this child some exposure to non-disabled peers, either in the context of the special ed classroom or by integrate her into some other program, into a pre-K program, or do we bite the bullet and pay at least for some time in the private regular pre-K program, okay? Plano ISD case is a Fifth Circuit case, kind of goes the other way. My Fifth Circuit is a very conservative circuit, meaning you view the requirements of the law in a narrow way. And here the school proposed, however, another child with ASD, the school proposed an inclusive pre-K program. So they did have a pre-K program, it was a regular pre-K program, and the pre-K program provided for special ed services as part of the pre-K program. And the parents instead, they wanted a private regular pre-K. And part of what hurt the parents' case is that in this regular pre-K that they wanted to place their child in, this private pre-K, the teacher not only was not certified, okay, but had no degree. How are you a teacher if you're neither certified nor have a degree? I'm not sure, okay. The school said, we're not sure that the IEP can be implemented in a private pre-K if it's not directly supervised by us, because the teacher is completely uncertified. The school had no regular pre-K. They only had an inclusive pre-K program, which is, for some level of interaction. And the court stated, we're not going to make the school pay for a private pre-K program where there's not even a teacher with a degree. And they went further. They said, we think the statute was designed to bring disabled students into the public educational system, not pay for private programs. So the Fifth Circuit had kind of offended their notion that a school might have to pay for a private pre-K program. And again, the Fifth Circuit kind of views things more narrowly. This is a little bit different than the position of the previous circuit courts, okay? So definite conflict among the circuits. And the question is, does LRE require creation of regular placements or access to private options to satisfy the IDEA's LRE requirement? And I will say that most of the federal courts say yes, that in order to comply with the LRE requirements for pre-K programs, you've got to do something to ensure that pre-K special ed students have an appropriate amount of access and exposure to non-disabled students. For you guys, it does appear that your regional centers where the pre-K kids go, that there is some attempt to bring in regular peers into the program, okay? Which means the program's not fully restrictive. There is some ability to interact with non-disabled students. The question is, for you guys, that you may have some students in the pre-K program who really could stand with a lot of exposure to typical peers. And if you guys are kind of providing the same amount of exposure to typical peers for all of the pre-K kids, it's standardized. Or let's say in one regional center, every kid gets the same amount of exposure to typically developing peers. And the question is whether the LRE requirement is being applied in an individualized fashion. That's what concerns me about your structure, is that generally, I think the courts in the Department of Education would require that LRE be applied in an individual fashion. Some kids, because of their needs, might stand for less participation with non-disabled peers, but some kids, because of their disabilities, could stand with more. And the more it starts looking like LRE is the same for all of the kids, despite the fact that the kids are not all the same, the more it looks like you're not applying LRE in an individualized fashion, that might be in violation of IDEA. Just a concern that I want to raise for you, okay? So the practical realities of your cases are that districts without pre-K programs do in fact risk LRE claims from parents of students with disabilities. So you've got to worry about that.
Jose, we have a question in the chat or a question and comment.
Sure.
One thing our district has tried to do in the past is run a small play group for students who turn 3 in January and try to invite non-disabled students to the class. Many times the ration is for SPED
the rationale probably.
Oh, rationale. 4 SPED, 3 non-disabled. Trying to increase the ratio, I think
Yes.
it's ratio.
Yeah, likely.
Non-disabled has been difficult. What are your thoughts on that as LRE?
So let me understand this question, because as I was listening, I'm also having to share the screen for the new presentation. Wait a minute, what am I doing wrong? Oh, I know what I'm doing wrong. I'm so sorry. Technology-wise, as my grandson points out, I am very much a boomer. So I'll ask you to repeat that in just a second.
Sure.
I think I shared it properly. Okay. All right. I've started to think about it, but I want to hear the question again.
Okay, so the district has a small play group for students who turn 3 after January. And the ratio is 4 sped to 3 non-sped. To try to increase that ratio is difficult. What are your thoughts on that as an LRE?
Well, first of all, I've got to say that this is a ratio that approximates equal, right? I mean, if you have 4 students with disabilities and you have 3 non-disabled students, that's pretty significant. I mean, think about it. The group of non-disabled students is almost equal to the group of students with disabilities. And I must say that if you notice in the analysis of the federal courts, there's not some sort of a quantitative analysis of the amount of regular education students. Although I think that's a piece of it, because obviously if you have 10 students with disabilities and they're exposed to 1 student without disabilities, there's only so much that a student without disabilities can do for modeling, right? And that starts diluting it. But if you have 4 students with disabilities and 3 students without disabilities, that likely offers quite significant opportunities for modeling, for interactive play, okay? And if you want to increase the number of students without disabilities, that's valid, but I'm not sure you need to for compliance with LRE. I will add one word of warning. Is you want to watch out and make sure that what is happening in the context of this play program is not that the 3 students without disabilities are playing separately and the special ed students are over here, which can at times happen, okay? That's where the adults and the instructional staff have to get in there and ensure that there is good mingling and good interaction between the students without disabilities and the students with disabilities, and not that the typically developing peers are off on their own kind of playing together and not interacting with the students with disabilities, because you want to facilitate opportunities for modeling, opportunities for interactive and imaginative play, opportunities for verbal communication, social communication, social interaction, so that that you have more of a rich exposure to the non-disabled students. To me, the quality is more important than the quantity. Okay, that ratio may be totally fine, particularly if the adults are keen in working and making sure that the non-disabled students, in fact, are playing and are socializing and are interacting with the students without disabilities. So that can be perfectly appropriate. And then the other thing that you have to think about is the time frame, because if the time frame for this play program is very limited as opposed to the total school day, and most of the school day the special ed students are segregated except for this play program, that's still problematic, because it does mean that for all of the special education students, they're getting a very limited amount of exposure to non-disabled students. And remember that part of what the law says is you want maximum enough time. So actually, maybe you're worried about the wrong thing. You're worried about the ratio of non-disabled students to disabled students. I'm more worried about whether the play program is very limited in time as opposed to the full school day for the special ed students. That's a bigger worry. Any other questions?
I don't see any right now. She said, thank you, that was very helpful.
Sure thing. Think quality and time frame. That has to do with quality. The more that the students with disabilities are with non-disabled students, the more that you can allow for the inherent and intrinsic benefits of mainstreaming to apply. Well, mainstreaming, this is kind of a little different in that there's not a regular ed class, but what we're doing is the next best thing, which is providing the benefits of exposure to non-disabled students within the context of their program. And I think the more time, the better. Okay, that's the thing. And again, the concern that generally the courts will require that the amount of exposure to non-disabled students is an individualized decision, is a child-by-child decision. So think about that. Okay, in the time that we have left, I want to cover some key issues on the COVID piece. This is a longer set of materials that I'm going to have time to cover, but I want to cover some important things. Okay, first of all, during the period of closure, we have been told by the Department of Education in Washington, this is straight out of the OSEP guidance that was issued in March, that, and I'm going to skip ahead, that during the period of closure, your duty to the special education and 504 students is to ensure that to the greatest extent possible, you implemented their IEP services or 504 services in the context of either online or distance learning instruction, whatever you did for students during the period of closure. And I'm assuming that you guys did something. The law says, the guidance says if you see services for all kids, you could see services for all of the special education students, but that's going to have consequences later on. If you provided services on a distance learning or online basis to students, then special ed students had to participate and you had to implement their IEP services, accommodations, supplementary aids, and services to the greatest extent possible during the period of closure. That's an important piece. And I think what this guidance envisions is an acknowledgement that schools might not be able to implement all services that are included in IEPs in the context of at-home instruction, and that the provision of alternative at-home services might not be as effective as in-person services in a structured school setting. And you're going to find that probably fairly commonly. That the kids made some progress with the online services, but maybe not really close to the progress that they would have made if they were at school. Okay. The position of the Wyoming Department of Education is that obviously you're going to, during a period of closure, you're going to have to adjust the child's services due to the practical difference between in-person classroom instruction and virtual education. Like you might have to vary the frequency or the duration of the services. Certainly, I think that in my experience, during the period of closure, school districts put together virtual or online instructional lessons, usually quite abbreviated. And then students were expected to do a lot of work independently. My closest example to a school-age child that had to go into home services is my grandson. And let me see, he was finishing the 3rd grade last year. In Texas, it closed mid-March. So from mid-March to end of May, he went on all online instruction. But my daughter, who was keeping close tabs on this because she had to help him, found that the actual time of online instruction averaged 19 minutes a day. So very abbreviated online lessons. And then the students were expected to do a lot of work independently. Now, the Wyoming Department of Education says when you move to online instruction, there must be no negative impact on a student's receipt of educational benefit as a result of shifting from school to virtual. If it would only be slow. So I think that's a mission statement. I kind of couch that. I've got a school district that says every child that graduates from the high school will be ready to proceed to a full 4-year university. You know, it's a mission statement. You're shooting for that. Now, if you ask me, is it possible to move all special ed kids of all kinds from school to virtual education without any negative impact on their educational benefit? To me, it's not possible, because the inherent and very unique nature of virtual education means it's not going to effectively meet the needs of all kinds of special ed students. And that shouldn't surprise us, right? Not every setting in the continuum of placements is able to meet the needs of every kind of student. The regular classroom can't meet the needs of every kind of special ed student, and the virtual setting can't meet the needs of every kind of student. But you're shooting for this, okay? By the way, I think that the reality that the online instructional context might not necessarily be a good fit for some students with disabilities is why the Department of Education acknowledges that you might need to do compensatory services later when schools reopen, okay? We'll talk a little bit more about that. So one of the cases that are starting to come out are state education agency complaints with respect to the school closure issue. And this one's out of South Dakota, the Brookings case, okay? And in this case, the parents of a special ed high schooler, they filed a state complaint. And the state complaint said, you unilaterally changed my child's placement to at-home services. Yeah, because the schools closed due to COVID. I guess the parents really opposed the closure of the schools altogether. They also alleged when you close the schools and move the child to at-home services, you failed to provide the special ed services that were in the student's IEP. And I noticed that the district developed what they called the Special Education Distance Learning Plan. Some states, they've kind of decided, well, what we're providing during the period of closure, we're going to call it different than an IEP. We're going to kind of call it a continuous learning plan or a distance learning plan. Whatever you call it, it's going to have to meet the standards that the Department of Education sets out, which means it's based on the IEP, because to the greatest extent possible, you have to implement the services that are on the IEP. The vehicle by which you do so, if you want to call it a continuous learning plan or a distance learning plan or whatever you want, that's fine. But you have to understand that the duty is to implement to the greatest extent possible what's in the IEP, okay? Now here the parents said, we don't want no distance learning plan. We reject the plan. We want in-person services. We want the kids to go back to the classroom. And if you notice, during the period of closure, the district actually provided some significant services. Reading instruction through Read 180 software. They provided the student a laptop, okay, so that's some significant resource, and headset, accommodations, Zoom, and video lessons, and daily communications with the parents. So, you know, pretty good, pretty extensive kind of substitute online / virtual / computer-based services to the student during the period of closure. Now, admittedly, it appears that not all of the minutes of speech therapy were provided per the IEP, and certainly not all the minutes of special ed instruction, that varied. And however, the state education agency noticed that the district was pretty diligent in keeping progress data during the period of closure. What an idea. I hope all of you, during the period that the kids were at home and doing online instruction, thought of how to keep monitoring the students' progress, whether in regular classes or on their IEP objectives or a combination thereof. That's going to prove crucial. It's important because later you're going to want to hopefully show what this district was able to show. And they showed the state education agency, look, the progress data indicates the student made nice progress on his IEP goals during the period of closure. Bingo, that's good. That's good right there. Now, the parents insisted distance learning wasn't effective and they had to help them a lot. But the state education agency disagreed that there was any violation. First of all, they told the parents, you can't challenge the school district closure. The governor closed the schools. Were you expecting the schools to rebel against the governor? In-person services were not possible during the period of lockdown, period. Moreover, the state education agency says the move to at-home services was not a change in placement. They don't explain why. Okay, I have some concerns about that position. And then they said the discrepancies from the IEP were minor and they didn't impede the student from making progress. So the SEA complaint went for the district. By the way, I want to add a little note. Okay, the state education agency did not address the parents' allegations that they provided a lot of assistance to the child because there was no documentation. You know, state education agencies and complaint investigations, they're highly document driven. And the parent kept no documentation of the assistance. They just probably provided assistance and are just verbally telling the state education agency that did so. But that raises an important question. What if the parents had kept daily logs of the personal assistance they're providing the child, and it showed that they spent hours per day working with the child? Would this be a valid factor in determining the adequacy of the at-home services? Maybe. Maybe. I cite you this case out of Pennsylvania, the Brianne C. case. And the court noted that the fact that the parents were spending up to 3 hours a day helping the student with the work was masking her true academic deficits. In other words, that she seemed to be performing better than she should have, but it was because the parents were artificially buttressing, and the student in fact had very significant academic deficits as shown by her evaluation. And thus the extra assistance that the parents were providing was validly considered. So we'll see. I raise this point because I think that a lot of parents of both special ed and regular ed students had to provide a lot of extra assistance to the students during the period of closure. Now you might say, well, so every parent of regular ed kid had to, yeah, but these are special ed kids and special ed kids are different. How are they different? They have certain entitlements under federal law to a free and appropriate public education that regular ed kids don't have, you know, by virtue of the deal between the state and the federal government to protect and keep sacrosanct the special ed students' right to an appropriate education, okay? Then more questions from the Department of Education. They say if a child is infected or gets ill with COVID and school is open, what happens? Well, you're going to have to remove the student, and the IEP team is going to have to kind of figure out what alternative services are provided, sort of like a microcosm of what we had to do with respect to all the special ed students when the schools generally closed. And that we get to next. Okay, so this is a sort of a process legal question the Department of Education asked. They ask if we exclude a child because they're ill, they're infected, or they're at high risk, maybe they have some pre-existing condition that will render them more susceptible to very serious complications if they get infected, and we exclude them from school, is the action a change in placement? And the Department of Education applies very traditional analysis. They say if you exclude a child 10 days or less, then no. But if you exclude a child longer than 10 days, then yes. And change of placement procedures have to happen through the IEP team, and prior written notice has to be issued, okay? And there's the language from, there's the actual question A4 and the answer in the March USDOE guidance document, okay? Now, I must say, normally, changes from in-school programming to virtual programming or virtual programming back have universally by the federal courts to address these cases been found to constitute changes in placement. Is that a far-fetched notion? That if you have the student in a live classroom environment receiving services and then they go to an online program in the home, that's a change in placement? You know, I've heard people say, no, it's just a change in the location. It definitely is a change in the location, but it's a change in the frequency of services and the amount of services, certainly a change in the modality, in the delivery method, in the type and nature of the services. It's a change in setting because the child's in a home setting. It's more restrictive because the child doesn't have access on a physical basis to non-disabled students. So it's a change very fundamentally. I have a hard time with this idea that this is not a change in placement. Nevertheless, I must say that a variety of states have done so. In fact, the Fairview case out of Pennsylvania says moving kids from school to a cyber or virtual school not only is a change in placement, but a virtual program in the home is the most restrictive option. In other words, you're saying because at the home, there's zero exposure to non-disabled students. Now, I've had people tell me, but on a Zoom basis, the kids are kind of electronically exposed to each other. But I must say that no federal court has recognized that some sort of virtual or electronic exposure counts for LRE purposes. To them, LRE is all about physical exposure, and I think that that is what the law envisions. In other words, the LRE regulations and rules as they existed in the last reauthorization, which is 2004, they predate online programs. They didn't envision that. The only LRE provisions that we have in the law, they envision live physical exposure to non-disabled students in a brick and mortar setting, not online exposure, okay? That's just the way that it works previously. So generally the cases say, these are changes in placement. Any substantial or material alteration to the child's program is a change in placement. But a variety of states are saying when generally there was a school closure, does this guidance, and the answer to this guidance question, aside from individual removals, is the guidance applicable to general COVID school closures? Or is that something else? Now, I must say that right off the bat, a straightforward opinion would be it also applies to group removals because the Department of Education guidance did not specify or clarify that general school closures would be treated differently. So the normal horse sense interpretation is it's not, and these are all changes in placement, and they had to happen either through the IEP team process or IEP amendments with prior written notice, okay? That's otherwise, why would the Department of Education not indicate what procedures? And it has surprised me, because a variety of states have taken the position that when the schools were closed generally, when we moved all the special ed kids to the home, those weren't changes in placement. And no IEP team meeting had to be held, no IEP amendment, no process that complied with IDEA procedural safeguards. And I am concerned about that. I am concerned that that is a risky position for some states to have taken. And it's going to be subject to litigation, and we'll see what happens. I mean, to me, I think the best practice is when you move kids to home instruction to have at least accomplished it through the IEP amendment process. That avoided you having all those meetings. And that when you move students back from virtual learning back to live instruction, that you accomplish that change in placement back likewise through the IEP amendment process, okay? Because I think it's a change back and forth. And to me, these changes, it's not safe to accomplish them outside of some compliance that comes within the framework of procedural compliance under IDEA, because IDEA ultimately is a law of procedures. Okay, so that's the concern there. Okay, I'll give you a Kansas case. This is also a state education agency complaint. I just want you to get the flavor of what these disputes might be. And for the Wyoming Department of Education, you might be dealing with some of these as state complaint investigators. Here, the state complaint involved a continuous learning plan that was provided to a 7th grader with ID during the COVID closure. And it provided for 2 hours a week of online special ed instruction. Notice, you know, I mean, divided by 5, 120 divided by 5 is 24 minutes. So 24 minutes a day, I guess, if I did my arithmetic right. Work packets, but apparently there was some other access to remote instruction, so there might have been more instruction in the 24 minutes, and the kid got his speech and OT probably on a teletherapy basis. This is a 7th grader with ID again, where the continuous learning plan had an area for accommodations, but it was left blank, okay? The IEP normally called for assignments to be modified to the 1st grade level. This is a 7th grader with ID getting assignments at the 1st grade level. And the parent said the assignments were all over the place. Some assignments were lower than 1st grade level. Some assignments were 12th grade level, then 6th grade level, 7th grade level, 10th grade level, 11th grade level. It was almost everything but what it should have been. State education agency said, if you left the accommodations blank, then we're going to interpret it as you left the IEP accommodations in place. Good interpretation, since that's what the guidance requires. Apparently, the Kansas Department of Education didn't like the fact that the staff went over the continuous learning plan with the child, but didn't afford a meaningful opportunity to participate. And the question I have about that is, if this isn't an IEP team meeting or IEP amendment, where does the parent's meaningful opportunity to participate arise from? Did the state pass some rule that says if you do a continuous learning plan, there has to be X meaningful participation by the parents? I think rather that what this Department of Education is wrestling with is, well, we don't want to call this an IEP amendment or a change in placement, but we're concerned that there's not a meaningful opportunity for parental participation. That's my concern. That if you're not making these changes within the context of the procedural framework of IDEA, then what gets sacrificed is a meaningful opportunity for parental participation that is at the core of those procedural requirements. Okay, that's the problem. Kansas says these aren't changes in placement because the school district didn't cause the school closure. Because the decision to close the school was not the district's decision. Any contingency learning plan doesn't constitute a material change in services. Of course it's a material change in services. How could it not be? The position that they're taking is because we didn't cause the school closure, this change isn't a change in placement. Can changes in placement not be occasioned by happenings outside of the district's control? Let's do another mind experiment. I like mind experiments in law. And I'll throw this one at you. Let's take us 2 years back in time to 2018. Seems like a million years ago now, like the Paleolithic era. But it wasn't, it's just 2 years ago. Let's say 2 years ago, you had a 15-year-old high school student in their SLD, and they suffer a severe car accident. And that severe car accident now has rendered the student homebound for 3 months. Thus, he has to be provided homebound services. An IEP team has to meet and has to provide for homebound services. Would we have taken the position 2 years ago that since the school did not cause the car accident, the move from in-school instruction to homebound instruction is not a change in placement? We don't have to have an IEP team meeting. Craziness, right? We would have never said that. Never would we have said that. Changes in placement often have to happen because kids' needs change in a manner that's outside of the district's control. That can happen. That can happen. A child's emotional disturbance gets worse. We have to respond by a more restrictive placement. It happens all the time. So I'm not satisfied by the rationale of the Kansas Department of Education. Hey, we didn't cause the COVID, we didn't cause the school closure, so these aren't changes in placement. And they participate in this fiction that the continuous learning plan isn't a material change in the services. Of course it's a material change in the services. It's a lot less instruction. It's totally different. It's in a different setting, and it's in a more restrictive setting. How is it not a material change in services would be my question, okay? And again, I think the big question is, how does the development of these continuous learning plans fit within the procedural framework of IDEA in a way that affords parents meaningful opportunity to participate as IDEA intended? Or is it not intended to fit? And if it's not intended to fit, what's your argument? And the Kansas argument doesn't work for me, okay? Now, aside, even though opinions can change on whether these were changes in placement or not, I think that these are changes, at least in the provision of an appropriate education, that trigger the prior written notice requirement. And I've cited you the regulation requiring prior written notice. If you're going to change placement, identification, evaluation, or provision of a FAPE, you have to provide prior written notice. So even if you don't agree that the change to at-home services due to COVID closures was a change in placement, you can't disagree that it's a change in the provision of a FAPE. Thus, and I think quite correctly, your Wyoming Department of Education says you've got to issue prior written notice. If a student with a disability moves from classroom instruction to virtual education or back, prior written notice must be issued at the very least. Absolutely, absolutely. A prior written notice that would explain, that would obviously tell the parents what change is being made, why, the data being considered, options considered. That's all the ingredients of prior written notice. The next question from the Department of Education, I think, is basically an invitation for a really smart and convenient practice. Look, as you reopen the schools, you're going to be faced with the following possibilities. That if your positivity rate increases, or you're still having significant rates of community transmission in Wyoming, that you're going to have outbreaks at school. And you're going to have to send groups of students home, or you're going to have to close the whole third grade, or maybe close a campus. And what this question is saying is, you could actually have a contingency plan in the IEP. What they're basically saying is, as you move the children back to home and to school, back to live face-to-face instruction, what you might want to have is a plan A. That's a plan for classroom instruction. It's going to be kind of regular IEP. Then you're going to have a plan B. Should we have to exclude you, or your parent decide to opt for home services, or the whole campus or district closes, this plan kicks in automatically. And I think that's a really good idea, because then you could accomplish the shift back to home instruction automatically without even so much as an IEP amendment, because the parent already knows what's going to happen, and it's set forth in the IEP document. So I think it may be smart, as you move the kids back to school, to have a plan B, a contingency plan in place in case that happens. Questions on the?
Yes, we have a question. What would the SPED service requirement be if a tornado destroyed the school and no students received education in that school or a rural district? Would that be comparable to a COVID closure? Would each SPED student need an IEP meeting to talk about changes while the school is being rebuilt?
Yes. I'm afraid that there is no waiver of FAPE or the procedural requirements that I can point to. In fact, Betsy DeVos, our Secretary of Education, had the opportunity under the CARES Act, the stimulus bill, to ask for waivers and flexibility on behalf of school districts, and chose not to. And she said, no waiver of FAPE, no waiver of LRE, no waiver of any procedural requirement. So if a tornado destroyed every school campus, I think that what would happen is you'd have to move the children to at-home instruction of some kind. You'd have to move them either, now there's options. It could be either through IEP meetings or IEP amendments. Okay, because I think the parents are entitled to know, what are you going to do for me? And to document it in some fashion. And to the degree that for a period of time, due to the disruption of the tornado, you were unable to provide services, then you would commit to providing compensatory services for kids. There's not an act of God waiver in the law that says if the district got swallowed up by the earth, then IDEA doesn't apply. As an attorney, I want to argue that. I'd love to argue it for you. I represent school districts, but I can't just argue it because I want to. I've got to have something with which to argue. So I think and by the way, the issue of the tornado destroying the schools, I haven't dealt with the issue of a tornado destroying the schools, but I have dealt with the issue of a hurricane destroying the schools. Or part of the schools. And districts have had to deal with this in Texas. We have a significant Gulf Coast, and we get hit by hurricanes pretty much on an annual basis. And the only difference is the severity. And then increasingly, they've become more severe. So we have dealt with situations where the district's sort of gone. Every campus has sustained such damage that it is not safe for kids to attend. And yes, we have had to find a way to move the kids, the special ed kids, to alternate home-based instruction in some process. Usually the simplest process is through the IEP amendment process. Yes, I'm afraid so. I mean, I have no other answer. I'd love to give you an answer that says, we can just quit and focus on recovery and that's it. And it's just, tough luck for everybody and that's all. But I'm afraid that the law doesn't allow for that. It just doesn't. Let me know if there's a follow-up. Okay, so think of the contingency plan idea because it's a good idea. Now, comp services. Here's a saving grace. District gets destroyed by tornado, and for 4 weeks, we're unable to provide any services to the special ed kids. The law says, we get it. We get it. But if you have been forced to miss instruction or services, you still owe them to the child. And you'll have to make them up by considering compensatory services at a later time. Okay, so I think the Department of Education recognizes it might not be possible to provide full FAPE to kids during a full school closure, but that you're going to have a responsibility later on to make that up. And compensatory education is like back taxes. You know, if you didn't pay your taxes in 2016, you still owe them on top of your 2020 taxes. So you owe the current FAPE, that's 2020 taxes, and you owe back FAPE, that's the 2016 taxes. And that's the responsibility of school. And then, by the way, totally recognizing that the school closure is outside of the district's control. Everybody recognizes that the COVID closures were outside of the district's control, but special ed kids have to have their FAPE back, okay? The Department of Education, Secretary DeVos, did not tell the Congress, we think schools should have a break with respect to FAPE during the period of closure. Wrong or right, that's the position that she took, because she said, we think that schools have other means to provide access to FAPE through online and at-home services, okay? But I do think that I want to distinguish the compensatory services that we're having to provide due to COVID issues beyond the district's control. So I like to call it COVID comp. I notice that you guys are calling it recovery well, I'm sorry, Washington. Washington is a state that's put out a lot of guidance on COVID, good resource, and they're using the term recovery services. South Carolina is using the term supplementary school closure services, because trying to distinguish it from compensatory services, which usually are ordered against schools because they did something wrong. And here, it's not that you did anything wrong. No school did anything wrong. The school closure was completely outside of the district's control. But in fact, kids have missed out on services potentially, and they're entitled to get those services back. Oh, you guys call them recovery services as well. I'm sorry, I forgot. And I think your Department of Education recognizes the US DOE guidance and says you're going to have to use recovery services to get back. Now, in the little time that we've got, I want to move ahead. I talk about, how to do the comp services issues, how to make the determination, but I want to talk about some reopening issues for schools. The materials were broad enough probably for a half-day presentation, and I want to talk about masks.
Jose, I might just throw out to folks that if they want to see this presentation in its entirety, it was done 2 weeks ago, and you could look it up on the WinWeb website, the recording of it.
It is true. I went into all of the areas in more detail with more time in a previous presentation, so you guys can do that. I want to address a couple of reopening schools. I'm getting a lot of questions about masks as kids come back to school, and I'd like to address those. Can schools require that kids wear masks? Yes, I think so. I think fundamentally ADA allows it, because ADA allows schools to impose legitimate health and safety measures that are required. You could conceptualize it as a dress code requirement that's even enhanced because of dress code. Or you could base it on the CDC recommendations, and the CDC recommendations definitely say schools should consider requiring kids to wear masks, okay? And now the questions are, should districts have policies for masks if they're going to require kids to wear masks? Yes, I think there should be an overall district policy addressing the requirement to wear masks. And should there be exceptions? I think so. If you look at the CDC guidance documents, and there's 2 that address masks in schools, they say you're not going to be able to get kids to wear masks if they have severe asthma or breathing problems. They're really little guys like pre-K kids. They have mental health conditions, ID or developmental disabilities, or have sensory or tactile issues. So you're going to have some exceptions. And in the situations where the kids can't wear masks, you're going to have to focus on masks for the staff, social distancing. You're going to have to worry about other things, okay? Probably a little much. I've been asked, if a kid can't wear a mask, can't we just send them home to home instruction, to a more restrictive environment in the provision of left services? And if they've got ID or developmental disabilities, can they really get a FAPE? in the online programs? I'd say probably not, because I'm concerned that they really can't get a FAPE at home and that it's a more restrictive environment where other safety measures can be put into place. And some school districts in the United States aren't even requiring kids to wear masks. So I'm not sure that you're going to be able to safely and legally send a kid home just because they can't wear their masks. Now, I do think that the exceptions in your mask policy should align with CDC guidelines, because the Office for Civil Rights has said if you treat individuals consistent with CDC recommendations, you're probably going to be okay as far as the law is concerned, as far as 504 and ADA. If a kid isn't eligible for a mask exception, I think they can go to their IEP and 504 meeting and seek an individualized exception, but I think it's going to be tough because they're going to have to argue, I can't get a FAPE if I have to wear a mask. And if you don't fit one of the exceptions, I'm not sure you're going to have a valid argument on that basis. And then if you have a child that behaviorally, no exception applies. They're supposed to wear their mask. They're supposed to socially distancing, but they're violating those rules. They're taking off their mask. They're coughing in people's faces. They're getting close to people. You've applied behavioral interventions. You've reminded the students, and they're still violating those rules. Can they be excluded and sent to distance learning? And I think that the answer is yes, but I think that it's likely to be seen like a disciplinary removal, because on its face, you're removing a student, probably long-term, longer than 10 consecutive days, due to misbehavior or a violation of district policy. So I think that it's likely that the law is going to view this as a change of placement that's disciplinary in nature and that triggers the manifestation determination requirement. I think that that's the likely way it's going to be viewed. And the last little bit I want to leave you with is you may be, and I am concerned with medically fragile students returning to the school setting during the context of significant rates of community transmission. The medically fragile students are probably students that can't be effectively or feasibly made to wear a mask, and you can't socially distance well because you got to get close to them to instruct them, but at the same time they have multiple conditions that likely place them at very high risk of very serious complications if they get infected with COVID. It doesn't help that even the doctors don't have a good idea as to what medically fragile means. And what I think states are wrestling with is that IEP teams have to kind of consider all of the information together and determine the safety piece versus the FAPE and LRE piece. And you have to look at doctors' information. So the LRE mandate says, well, we want these students in campus settings, but health and safety priorities say they should be at home. FAPE priorities say they should be at school. So everything seems to be pulling in different ways. So I think that's the dilemma for schools on the medically fragile kids. I think some parents are going to say, my medically fragile child, I want to stay at home. I think the problem that's going to kind of come up is when the parent of a medically fragile student wants them to be at school, but it's a situation that creates a significant health and safety risk for the child. And what's the IEP team's response in those types of situations? If I do think that the IEP team would have the authority to say, we think that based on the fact that they can't wear a mask and instruction has to be real close, that we're going to have to put them on some form of home instruction for their own safety, but that could be subject to some legal challenges. And it's legal challenges of the type we haven't seen before. I'm not exactly sure how to answer the questions because these are going to be cases of absolutely new impression.
Jose, before we leave, we have one question.
Sure.
Do you need to make up the special education services if the student made appropriate progress after coming back to school? And how long of time is reasonable to determine if they are going to make up the progress before you just decide about compensatory services?
Good questions. I'll take the last first. I think that since natural recoupment is possible once kids return to school, and you will find that some kids after return to school, whatever ground they lost, bam, they made up. For me, I think that the 6 to 8 week period makes sense because it's short enough that it's within a grading period or so, but long enough to allow for natural recoupment to take place, long enough to allow for staff to data collect and reach more accurate views of exactly where the child is now. So, and in not so long that parents are going to think you're delaying the compensatory services determination. So 6 to 8 weeks, in my opinion. Okay. And then if the children come back and it is seen that they made appropriate progress during the period of closure, look, for some kids, online instruction fits like a glove. They love it. I mean, it's totally awesome. For some kids, they have a lot of motivation. They're self-starters. They do work independently real well. These are the kinds of kids that are not falling behind. If they didn't fall behind, no comp services are warranted. And if they naturally recoup their losses within a 6 to 8 week period, I think no comp services are required there either.
And Scott is following up with when and where do comp services happen?
There's choices. Some choices are during the school year. It could be by increasing special ed services and related services sessions during the school day. It could be by adding before or after school compensatory sessions, or it could happen in the summer, or it could happen with a combination of these. There's choices there.
Well, Jose, thank you so much again for joining us. We sure appreciate hearing from you and you taking the time out of your busy schedule to support Wyoming. So thank you very much. I really
appreciate the opportunity. I only miss traveling to your great state and viewing the great sights. You guys have a state that's very, very nice to drive in. It's very beautiful.
Well, we'll have waves again sometime in person.
Great. I'd love it. I hope everybody stays safe, and I wish everybody the best of luck in reopening. Thank you very much.
Thank you so much. I appreciate it.